Welcome everybody, we'll get started. My name's Matt Dana. I'm the managing partner of Dana Whiting Law. If you've been around Scottsdale for a while, you know our beautiful buildings right here on Bell and the 101. You can see it from the freeway. It says Dana Whiting Law. We've been there for over 15 years. We've had our office here in Scottsdale for over 20 years. I started up here on Perimeter with 1,500 square feet. Then I moved on Bell Road at 3,000 square feet. And then I moved on the freeway at 6,000 square feet. So our firm has grown, done well. A lot of you remember back to the Dana Law Firm days. I'm the founder of Dana Law Firm. When you Google the Dana name, you'll see a lot of Danas in there. Both of my sons are estate planning lawyers. And so you'll see Dana Law Group, which is the law firm I started, and then Dana & Associates, which was my first law firm. In 2014, I had my two sons working with us, plus all of my daughters, and it got to be too difficult to be a dad and run a law firm. So we decided that we're all better off to kind of split up and go different directions. So I took some of my guys and started Dana Whiting Law. Trevor Whiting's my partner. He's not here today. I have two of our younger attorneys over here. We've got Michael Rich is with us today, and Hallie Tessendorf's here with us today. They'll both be speaking. I'll start out, but I want to just give you a little bit of background before we get into the materials, and hopefully you'll really appreciate the content that we put into these materials. This isn't just one of those seminars where they give you a little bit of basic information. We give you a ton of information in there. You'll see a bunch of articles that I've written here in the back on a lot of the topics we're going to talk today. I promise you that if you read those articles, you'll understand a lot about estate planning. Let me go ahead and use this since I've got it. But if you take a look at those articles, that one, Planning with Purpose, I think is a very good article. I talk about how I've been practicing for 40 years, and my estate planning practice and expertise has evolved over those 40 years. I'm quite a different estate planning lawyer today than I was as a young lawyer. And I like to say I don't practice estate planning, I'm living estate planning. And I don't know how you can really understand estate planning until you've had 5 children get married and you experience some divorces and maybe some deaths and bankruptcies along the way, experiencing grandchildren. All those things are very important parts of estate planning. And if you're watching this whole estate planning area, you know there's a lot of development in this space. I want to give you a couple recent developments that I think is really impacting the way that estate planning is being practiced. First of all, understand that Arizona changed its rule a few years ago that you don't have to be an attorney any longer to own a law firm. And so we have private equity getting into the attorney space, just like we saw private equity get into the dentistry and the medical space. And it's changing that. And in fact, I saw an article just a couple of days ago that KPMG, the largest, one of the largest 4 accounting firms in the world, has now opened up an alternative business practice here in Arizona, and they'll be opening up the KPMG law firm. So that's a real interesting development, how private equity and accounting firms are getting into the legal space. Second thing that's I think is a real interesting development is the fact that the financial firms are now getting very heavily into estate planning. You see on TV a lot of these financial firms advertising that they offer estate planning, and they can because now this alternative business structure rule. And a lot of the big financial planning firms in the country, like LPL Private Ledger and some others, they're all starting online estate planning services. Wealth.com was private equity getting into the estate planning online business. And so that's why you saw in my particular advertising material, I basically raised the question, using a seasoned estate planning lawyer is much better than using your financial planner who uses an online tool to do your estate planning. And so the two main goals, what we want to accomplish today is, I'm not here to try to convince you whether you need a trust or not. I'm hoping you're all here because you understand you do need a trust, but this isn't going to be one of those seminars I'm going to try to convince you need a trust. This is one of these seminars where I'm going to show you all the different provisions in a trust, because I think that the fact that financial advisors are in this space and accounting firms are in this space, I think they make it sound like every trust is the same. So it's almost like I've got a trust. Well, you know, it's not hard to have a legal trust in Arizona. I mean, I could create a legal trust in probably 3 paragraphs. But as you're going through this seminar today, you're going to see all the different provisions that should be considered in a trust. And I'm going to make the argument, how do you think you can make this type of a trust online using a financial advisor that is not a seasoned estate planning firm? So what I'm here to convince you is why you should use a seasoned law firm to create your documents, not an online law firm or not financial planning. Just a couple more introductory comments. So I started the practice of law in 1984. I opened Dana Law Firm in 1989. We grew it to one of the largest estate planning practices in Phoenix. In 2014, a national firm knocked on my door, Quarles and Brady, and I went and ran part of their national law firm, their estate planning practice, for a few years. Found out I hated corporate America, and I hated the fact of some bankruptcy lawyer in Milwaukee trying to tell me how to run a estate planning practice in Arizona. So in 2017, Trevor Whiting and I decided would form Dana Whiting Law. And then, like I said, our building's just right down the street here on Bell and the 101 freeway. With that introductory, let me introduce Hallie Tessendorf first. And the outline that we're going to be going through today is the 10 most common mistakes in estate planning. And I'll tell you that I've written every single word in here, and it's evolved over my 40-year career. And I just recently did a modification on here, just finished that modification last night. And I really sat down and thought over my 40-year career, what are the most common mistakes people make in estate planning? And I've kind of listed them in order. I'm going to have Hallie talk about the first 2.5 mistakes. Then I'll jump in and talk about mistakes 3 through 7, and then we'll have Michael come in and talk about mistakes 7 through 10. So Hallie, with that, go ahead and turn this over to you.
Thank you, Matt. I'm Hallie Tessendorf, and I am an Arizona native, and I actually graduated from law school in 2014, and I started with Dana Whiting Law just when they started back up in 2017. And I think over this time, what I really appreciate about the firm is how much they value educating our clients about what's right for them, not just a template and here you take what it is. We also have the opportunity to work from a trust administration perspective, so we see what happens on the other side, and then we use that to help us estate plan for clients and make sure that we don't have the pitfalls that we sometimes see happening. One of the first ones that Matt asked me to speak about is the failure to plan. And I think when many clients come in, the first thing they say to me is, I know I should have estate planned. I haven't done it yet, but I'm here. And that's always my encouragement is, you're here now, and we're gonna do it now. And people, when they fail to do their estate plan, I think the first reason that they typically do that might be they think, I don't have so much money that I need to do anything. I'm good. My spouse is on my house and my kids, they're gonna be fine. In Arizona, we have what we call a small estate, but it's not relatively large. If you have over $100,000 of equity in your home, or you have $75,000 of tangible assets in your bank account, in your investments, your vehicle, your checking account, that's going to trigger probate. And probate is the process of transferring assets from you to your chosen beneficiary to a beneficiary. But it takes time, and it's usually through filing papers with the court and appointing an executor, and then waiting and following these rules that we have. So people think, well, if I have my spouse, I'm good. But actually, we often see that there's a reason to estate plan, even if you have, even if you're over those numbers. And the other thing that we see people saying is, well, I see that this estate tax is for people who are very wealthy. I don't have to estate plan unless I'm way over that. And again, it's not about taxes here, it's just about what is the most efficient way that we can have what we have go to our chosen beneficiary. That's what estate planning can do. Another reason that people don't do their estate plan is that they don't see the benefits of it. They think, well, I think it's going to go the way I want it to go. I hope that it will. But actually, an estate plan can do many things. And I think that's what Matt's going to touch on later, and why you see it has value beyond just a fill-in-the-blank form. But one of the main ones is that it allows you to control assets beyond the grave. So we think of this as a legacy. What are the ways that we can help our family learn how to invest, or help our kids grow into, if they're minors, receive their inheritance in a way that's protected? We like the idea of protecting grandkids from being disinherited. If I pass away and I leave it to my kids and they're married, they can do whatever they want with it. It may go to a new spouse, and my bloodline is disinherited. So by estate planning, we have the ability to put in protections to make sure that we have our family cared for by what we worked hard for. We can provide training wheels. We like the idea of using our estate plan to teach the next generation, to give them training, either helping them be a part of your estate plan and including them in your meetings, meeting them with the CPA, or giving them a partner with a co-trustee in your trust to kind of figure out how to manage your assets, manage the trust when you're gone until they're ready to take over. Now, this may not be something we do for everybody, but there's reasons why that would be great for some clients. If you just don't do any estate planning, Arizona has defaults. They say, okay, it's going to spouse. Okay, if you don't have a spouse, it's going to my children. But what we can do with estate planning is when we have a complicated situation with second marriage or children, or we want to include grandkids, we can make that plan by doing a will and a trust. If you don't, you're going to be stuck with what the state says is their default. So we like to be able to do some planning and choose who our beneficiaries are. An estate plan really importantly allows you to appoint guardians for minor children. And that's just an important protection. When I have young families come in, they want to make sure that if something happens to them, if their spouse passes away, who's going to take the kids? And through your will, you can actually pick that person and not have to go through court procedure to have the family kind of fight over who the children should be going home with. Avoiding probate. Number one, we all worry about probate. I spoke about it. If you have over $75,000 of tangible assets or $100,000 of real property, we're going to go through the process of probate. And that's a court-supervised process of moving your assets to your beneficiaries. But a trust avoids that. A trust doesn't make you have to go through filing things with the court. It doesn't have the time frame that you have with the court. So probate's a great way to avoid, trust is a great way to avoid probate. And then the last one under kind of failure to plan is that we get to keep what's in your trust private. It doesn't go get recorded with the county. It's not public information. And so that's what happens through probate is papers are filed with the court and then part of the public record. But with a trust, we get to keep that private. And so we think that there's many benefits to why we might want to do some estate planning.
I just wanted to emphasize what Hallie's talking about here. I put this in a particular order because when you talk about the failure to realize the benefits of estate planning, I think the youngsters out there that are doing seminars and preaching on this stuff and all the online stuff, they spend all their time and material talking about avoiding probate like that's the biggest boogeyman in the closet. And probate's a boogeyman. Here you go, Michael. Might be the president calling just a minute. No. Avoiding probate's a boogeyman, but it's not the biggest boogeyman in the closet. What I talk about, the biggest benefit in estate planning in my mind is what Hallie talked about, they're controlling assets beyond the grave. That's something you can't do in a will. That's something you can't do in an IRA. And I'm talking about, I don't want to die and just leave the assets straight up to my kids and hope that they're smart enough to know how to invest it. And I know you'll say, well, my kids are smart kids, and smart kids can balance a checkbook, and smart kids can have a job, and they can pay a mortgage. but they may not know how to handle $1 million or a couple million that's coming their direction. And maybe they're going to go out and invest it in crypto or whatever's kind of the latest thing. And so when Hallie's talking about controlling from the grave, we really think that the biggest advantage of a trust is having these bumper guards and protections, and we'll talk a lot about those bumper guards and protections. But I list that as the most important, is that controlling from the grave. And Hallie, does anybody have any questions about this whole first thing? And the other thing I wanted to mention just quickly was that $13,900,000 federal estate tax exemption. Keep your eye; it's going to be a hot topic in the news. And certainly estate planning, when you're over these federal exemptions, is very important, because we're tax attorneys. If you look at my qualifications, I'm a CPA as well as an attorney, and those initials LLM you see there, I have a master's degree from New York University just in taxation. So I've spent my entire life talking about taxes, and there again, I don't know how you can be a very good estate planner unless you understand these taxes. And the 13.9 million is a federal estate tax exemption, and a lot of us are below that limit. We're not worried about it. But later on in the seminar, we'll also talk about how estate planning can impact capital gains and stepped up basis, and that impacts every one of us in this room. There's no exemptions for capital gain and stepped up basis.
I know of a couple of clients in this, or individuals in this room, that have estate plans. I was speaking with Carolyn earlier, and we all know that we have an estate plan, so we're good. Well, one of the things that we think is a mistake is people don't actually revisit their estate plan frequently. And by revisit, we mean look at it, meet with an attorney, make sure it's still current, and then update it if needed. And so some of these mistakes might be that estate planning is not one and done. So I said people come in and see me and they say, well, I don't have any estate plan set up. And I say to them, I'm glad you're here, you're doing it now, but this isn't going to be the last time you see me. We need to look at this in 5 years. We should make sure that we meet again and make sure that this still works as life changes. And so one of the main reasons that we meet with clients is when there have been significant changes in tax law. And as Matt said, that's going to be happening the end of this year. And as we have, the years progress, there may be some big things that we want to make sure we make your trust better, or we want to make sure we've evaluated if we need to do any updates. And that may be the case in Arizona or the federal tax law. Another one might be if you have a divorce. So if you and your partner get divorced, now your joint trust estate plan doesn't work anymore. We need to make sure that we change it. We need to set up 2 separate estate plans, and each of you need to take care of your assets. We have so many situations where people don't redo it, and it ends up causing a big mess. So when someone gets divorced, that's a time to come see us, make sure everything's fine. Another situation that we see often is that someone's lost a spouse. And that is the time that you need to come in, because most often these estate plans have something that happens as a result of a spouse passing away. Do we need to create a new trust? Do we need to make sure that your agents are updated so that you have the right people who can help you? You've gone through all this work, but now it's not the right people anymore. So we want to make sure that if you've lost somebody, that you come and you see us and you make sure that it's updated. As we age, as our kids age, as we enter new life stages, it's really important to come have your estate plan updated. Have you changed jobs? Have you retired? Have your kids become adults, or now they have grandkids? Those are going to be really important times to think, do I want to include my grandkids in my estate plan? Do I want to set something up for them to go to college? Do I need to make plans for my mother as she's aging? What things can we do? So as life circumstances change, it's really important that we take a look at how your trust fits or how your estate plan fits and if it's still working. And then the last one is you're changing your estate size. We always joke that they'll come see me when they win the lottery. And yes, please come see me when you win the lottery. But also, as life changes, and you know, right now my business just started up, but in 10 years it's now a thriving business. That we need to see, and we need to make sure that we make changes and that we have your estate plan adjusted to accommodate that. There may be tools that Matt has in his tool belt that will help with capital gains tax or protection for the kids or managing a large corporation. And the trust needs to accommodate those things. And so it's always important that we don't just think of it as, I'm done, I set it up one time and I never have to worry about it again. But if you have something in place now would be a great time to make sure that things are the same, and maybe even that we've funded it properly.
Thanks, Hallie. And I want to drive a couple points that Hallie said. You know, it's not a one and done. You know, anybody that sells you on the idea you do a trust and you're not going to have to see a lawyer again, don't buy into that, because there's so many things that we can do, you know, in an estate plan with all these changes that impact. And one thing that we offer as a firm too is a subscription agreement where you can pay a flat fee of $500 a year, and that entitles you to one free consult every year, entitles you to unlimited phone calls regarding funding your trust. It entitles you to make unlimited changes to your documents as they relate to who's the trustee and who's the guardian and some of these things. So we'll talk a little bit more about that. This change in tax law, we've mentioned it twice now. You know, we're keeping our eyes, dialed into Washington right now. As we know, there's a bill that's coming through the House of Representatives right now, and there's a separate bill that's coming through the Senate right now. And each of those bills have significant tax provisions in them, and they're winding their way through. How they end up, remains to be seen. But I do want to point out again, there's no question we're going to have a significant bill this year, because the Trump tax credits that were put in place when he was during his first term, they all expire the end of this year. For example, that $14 million federal death exemption, it sunsets to $7 million by the end of the year. And there's a big debate going on whether we will see that sunset or not. And we also see a lot of push and pull about what's going to happen to the capital gains, lowering the capital gains rate, and this idea of step up in basis. But is anybody, by show of hands, how many are familiar with this rule that when somebody dies, capital gains are forgiven by step up in basis? Are you guys familiar with that? So this whole step up in basis concept, it's not automatic. There's ways you can screw that up where you can die and don't get that step up in basis. We're dealing with a case right now in California. We have offices in California as well, where somebody died and held an asset as joint tenancy with right of survivorship and not community property, and there's a real question whether step up applies. Some of these trusts that we're going to talk about here in a minute, there's no question that putting your assets in certain types of trust, you will lose the step up in basis. So we'll talk about that and these changes that are coming in. Hallie, I liked her explanation on change in our age, and there's an example of somebody that hasn't aged to 68 yet. I want to tell you what I mean by with all the gray hair and the 68-year-old change in age, and I already mentioned it earlier. I'm significantly different attorney today than I was 30 years ago because I've experienced life. And I found out that I like my grandkids, Hallie, better than some of my kids. And so I'm giving a bigger portion of my estate to the grandkids. And that's been a significant change. And then that's an interesting debate with the grandkids. I've got 19 grandkids, right? So I've got a pile of them. But maybe I've got one kid that's got five children, and I've got another kid that doesn't have any kids. And it was interesting when I started talking about giving a big part of my estate to grandkids, how the particular son that didn't have any kids was kind of mouthing off a little bit. He thought that was unfair, that our wealth is going to grandkids. And then when it goes to grandkids, how do you balance that out? Should it be that, the grandkids, I should give a 1/5 share to one child to give to all their kids and another 1/5 to another child to all their kids? Or do I treat the grandkids all equally? So these are all things that you have to wrestle with, and these are all things that I've wrestled with, and that's what I'm saying when it comes to age. I've changed dramatically, and also I think as I've aged, I feel that need more to give back to charity and thinking the kids are going to be fine. But Does anybody have any questions about these changes of life? All right, let's move on and let's go to number 3, Hallie.
I'm going to start this and then Matt's going to finish. I'm just going to talk about having, an estate plan that doesn't fit your needs. Basically, it's the wrong size, it's the wrong fit. It's an improper estate plan for what you have and what you need. And clients come in and they'll say, I have a will, I'm good, goes to my kids, I don't need to do anything else. But that's because they don't quite understand what a trust does. We talked about a lot of these things, but a will is just you putting in writing your wishes of who is going to be your executor. In Arizona, we call that a personal representative, and where your belongings are going to go. It doesn't have any power right now. It's something that comes into effect when you pass away. Now we have your will and we go through probate. What a trust is, how it's different, is we create it now and it comes alive now. It owns assets and it has power and you get to manage it during your lifetime. And the things that we get to see it do is that it has the ability to give us control beyond the grave, like we spoke about. We get to say, I'm going to make sure that my kids get their inheritance in a way that they won't blow it and it's protected, and then they can learn how to manage it. The trust can also give away, so when we have a trust, we can say as the trustee, I'm going to hire a financial advisor. And so through that, we can have a financial advisor, investing our assets, and your trustee can continue that when you pass away. So we can designate, make sure that you keep using that financial advisor. Make sure that my money stays invested this way. So it's a way to control, again, that's really beneficial to the family. We spoke about training wheels. A trust, where a will just says, here's my assets, here you go, take them. A trust gives them time to learn how to understand how to manage it. And what a trust means is that an account is set up where there's a manager and the beneficiary, your child, gets to have the benefit of the funds. But it's not necessarily going to be fully in their control until they've learned. We get the idea of a greater inheritance. So rather than just taking it and saying at 18, here you go, child, here's your inheritance, and then they go and spend it on a car, right? When it's in trust, when somebody else is managing it to protect them until they're responsible enough, we can see growth and we can see investment that's going to actually help the family in the long run. We can see a legacy where that inheritance stays for the grandkids and great-grandkids. And then, as we spoke about, it does avoid probate. It does take what you have and it's going to pass it without having to go through probate with all that red tape, basically.
So now we're kind of done with a little bit of some of this warm and fuzzy stuff, and we're going to get into some really meat of the estate plan and what these different types of trusts should look like. What I want to talk about, I want to mark this for you. I'm at the top of page 5 where it says there are 4 main types of revocable trusts. I want to show you those 4 main types. And then in your materials, you have some flow charts. And over on the left-hand side, one says discretionary AB, one says traditional AB, and the third one, you see the flow charts? They're in the very back of the materials. They're right there where your thumb, there you go, right there. There you go, got them? So you got the discretionary AB, the traditional AB, and then the third one, it doesn't say anything on it, but on that third one, I would call it an AB+. So make that third one an AB+. This part of the discussion where you talk about having an estate plan that fits your situation, I like the way Hallie said that we also do the administration when somebody dies. There are law firms that just set up a trust, and then when the husband dies, where does the wife go? And I always wonder, all these guys that are doing this online stuff, who are they going to go see when mom dies or dad dies? They're not going to do any administration online. And so I'd list that as one of the big advantages of using a law firm. Who's going to be there to make sure all these provisions are carried out? On these different types of trusts, we talk about having things that fit. And it surprises me when a client loses a spouse and the client comes in and we're explaining the way their trust works, and they just seem surprised and shocked of how it's working. And especially when we start talking about this split that we're going to talk about, when this is the most one of these versions is the most common type of revocable trust known to mankind for married couples. If you're a married couple, you'll have some variation of one of these three. And online, they're going to give you one variation, and you're not going to know the other two. And I'm going to tell you right now, there's a huge difference between 1, 2, and 3, and you need to understand them very, very carefully. And we talk about having an estate plan that fits. And you know, I always compare it to having a suit that fits, having a jacket that fits. You can button it up, and I'm proud to be wearing this jacket that I've probably had for 10 years, and I can still button it. But thank goodness for Ozempic, right? You know, a few years ago I wouldn't be able to button it, but Ozempic's worked miracles for me, about 15 pounds. So if you want to see the variation of my suit sizes and my face, go to YouTube videos, and Dana Whiting Law, we've published 40 videos on YouTube. Did I say TV? We're not on TV yet, are we, Noah? Not yet. What are we on? Just the YouTube video channel, right? I didn't even know what YouTube was until Noah explained to me a few years ago I thought I needed to change a toilet seat, so I go on there and figure out with YouTube how to do it. But he convinced me to produce these videos and put them on YouTube, and I thought he was crazy. And then we produced the first video, and we did 40 minutes, and they thought I was crazy. They said nobody's going to watch a 40-minute video. Go on YouTube. That 40-minute video he's talking about now has had over 150,000 views. And a lot of clients that have hired us have told us they've watched that video 2 or 3 times. And so I'd encourage you to go see those videos. And we have them on all different topics. So just go to YouTube and punch in Dana Whiting Law and pick out out of those 40 videos, pick out a topic. And we talk about not only creating the trust, we talk about administering it when one spouse dies, administering it when 2 spouses die, so forth. But on these trusts, let's talk about the first one first. Michael, put up the discretionary AB trust. And this is the most basic variation. Now you're going to see out of all 3 of these variations, they have one theme that's in common. That theme is when one spouse dies, the trust will split into two separate subtrusts, a survivor's trust and a decedent's trust. And it's a physical split and division of the assets. And so the first question you should be asking is why would a married couple, when one spouse dies, why would they want to split that trust? And if you see the division here, you look at the survivor's trust in red and see that it's a revocable trust. And then if you see the decedent's trust in green, you can see that that's an irrevocable trust. And so when the first spouse dies, the assets are split. And it's not like we take the house and split it 50-50. We take the total value of the estate. And let's say the total value of the estate was $5 million. Then we would split $2.5 million into the red box, $2.5 million into the green box. And the surviving spouse would still live off of both boxes. The red box is revocable, meaning the surviving spouse can remarry, give that to a new spouse, give that to stepchildren. The green box is irrevocable, meaning the spouse can live off of it and they can enjoy their health, maintenance, support, benefits. But the surviving spouse, if they do remarry, they can't change the green box as far as who gets it. So that was my wife Nancy that left, and she wasn't embarrassed to say she's going shopping over at Kierland. So if any ladies want to join Nancy over there, she's looking for something to wear to a Western event tomorrow night. But Nancy will tell you that our trust, when we die, when either one of us dies, we're going to do this split. And here's why the clients like to split. And I want to say I do believe the split is a good way to go. Now in your outline, I talk about another version of a trust, and I call it a continuation trust if you just look at your outline. And on the continuation trust, it would be husband dies, everything just continues for the surviving spouse, no split at all. Now, here's why I like to split and why I don't like the no split. First of all, Nancy and I we're very open about it, that if one of us dies, the other one of us would probably remarry. We're both people persons. I couldn't stand the thought of eating dinner alone or traveling alone or doing those things. And getting remarried is not a bad, terrible thing, right? But what would be a bad, terrible thing is if Nancy died first and I'm still alive, that I remarry somebody. Her biggest fear is how much younger is that somebody, and she's made me promise that somebody can never be any younger than our oldest daughter, which puts me at about 43 right now. So that's my 68 to 43 is kind of what my range is and what my promise is. And it's not a terrible thing that I remarry. It's a terrible thing if I remarry and leave the estate to a new spouse, and then the children are disinherited. And so with this split, there again, Nancy dies first, we split the trust. If I remarry, I can amend and modify my side. It'd be like the assets are divorced, and if I want to remarry and do something with my half, I'm free to do that. On Nancy's half, she goes to the grave. I still get to live off of it. I can still take the income off of it. I can still change the investments on it. If I remarry, I can't leave that to a new spouse. And so that's one big reason we like the split. Another reason we like the split is that, let's say there again, Nancy dies first. Say my health is terrible, heart problems, this or that, kidney problems, whatever. Our biggest fear in life as we age is nursing home cost and the expense of that. And another challenge I have is trying to take away a driver's license from a client that shouldn't be driving, and they're getting into accidents. And so if you do this split and there's some type of a creditor, whether it's a car accident or a medical claim, they can attach the red assets that are mine, that are my community half. They cannot attach Nancy's half over here in the green box. And that has to be true if that word is irrevocable. You can't get creditor protection from a revocable trust. It has to be irrevocable. And so the split's a good thing. Now this first version is what a lot of online programs talk about, is they make this split discretionary. See where it says disclaimer, that word disclaimer? Michael, I want to modify that flow chart for the next presentation and put 9 months. 9 months. Under this version, that split is optional to the surviving spouse. Meaning Nancy could wait till I die, and then she could decide whether she's going to split or not. And it's a horrible result. Some junior lawyers or young people or online people might think, well, that's a good idea. Let's give the surviving spouse the option. It's a horrible idea because the spouse will never split the document, and it'll never happen, and they'll never get that protection. Plus, even if they do choose to split it and take that option, that green box is not as flexible as the next green box I'm going to show you, where if we force the split. So go to the next slide, Michael. The next slide is, we call it in here we call it a traditional AB trust. I would probably take my pen, and under the word traditional, I'd probably write the word mandatory. I'd make that a mandatory AB split. And that's what Nancy and I have. If I die or she dies, that trust will split. It's mandatory, right? No option. And by making that a mandatory split, it actually makes it more flexible for Nancy. If you look under here, and this is what's wrong with doing estate planning online with advisors, those flow charts probably look pretty close and pretty similar than the one you just looked at. Big difference. Notice this one has the word power of appointment in it, and the other one didn't. So circle that power of appointment, 5C, non-taxable power of appointment. Circle that, 5C, a non-taxable power of appointment. If you have an optional split, you cannot have a power of appointment. But if you do a forced mandatory split, the survivor can have a power of appointment. Now, what that power of appointment means, let's put this in perspective. I died. Nancy lives for 20 more years. We split the trust. She's living off of both sides. She's seen changes in the kids and the grandkids that I didn't see. I've been gone for 20 years. She's seeing a grandkid that has a greater need. She's seeing of somebody that has a lesser need. She wants to modify percentages of what the kids or grandkids get. I can give her a power of appointment, even though that trust is irrevocable, that she can still dictate and change who inherits it when she dies. Now I make that a limited power, that she can have the power to change, as it says here, to descendants, kids and grandkids, spouses of descendants, not a new spouse of Nancy, but say my daughter dies, Nancy's still alive, and she likes the son-in-law, and she'd just as soon give that share to the son-in-law. She can do that. Descendants, spouses of descendants, and charities. I'm okay if Nancy changes it within that group. Who's missing from that group is new boyfriend, the pastor in your church, the guy at the nursing home painting your toenails. I mean, I don't want her to give it outside the family, but I'm okay if she changes it. But there's a subtle difference. I don't know how you could see that difference if it wasn't explained to you on that power of appointment. The other thing is, if you take a look at that decedent's trust, and you look at the provisions in there, and this needs to be designed on how flexible do I want to make that for Nancy? Or how restricted do I want to make it to Nancy? Now that depends on how long we've been married, right? Nancy and I have been married 47 years. I want that to be as flexible as I can. On the other hand, what if Nancy was a newer spouse, who had only been married, say, 5 or 10 years? I would want that to be more restrictive. It's not one size fits all. Now look at this here. I've made it very flexible. Here I've said trustee. The trustee could be Nancy, the surviving spouse. Michael, change that to put surviving spouse. It just says survivor. Surviving spouse. Nancy can be the trustee. Nancy can take out all the income. Nancy can take out principal if she needs it for her support and maintenance. You see that? And she's the trustee and she decides what's support and maintenance. Now, if she was a newer wife and I wouldn't want to give her that much flexibility over support and maintenance, what I could do is say she can take out all the income, but on principle she can only take out 5% per year. I could make it more restrictive. Each one of these clauses, I can make them very flexible or restrictive. And there's not a right or wrong, it just depends on your situation. But I just don't know how you get all that variation trying to look at this stuff. And then look, in either case, when both spouses die, it comes down to trust for the kids. And I'm going to talk about that. I think it's a huge, huge mistake to have an inheritance that when you die, it just goes straight to your kids. We're big believers that you create trust for your kids inside of your trust. Those are called subtrusts. So when Matt and Nancy are both gone, there'll be one separate subtrust for each of our 5 kids, and their inheritance will go into that subtrust. Why? Creditor protection for that child. And who's the biggest creditor that child has? Is a person sitting beside them. Divorce, 50%. If that inheritance is in a subtrust and my daughter divorces, that spouse isn't getting any of that. That's not community property. That's a separate property that's wrapped up in a wrapper. If that client starts a business and it fails and there's horrible lawsuits, that trust is bulletproof. And if you look at this online, they'll call these things dynasty trust or legacy trust. In that article that I've given you in the back of my materials, I talk about planning with purpose. And I talk about there's a difference to leave your kids a legacy instead of an inheritance. An inheritance is you die and they give it and they go down and they buy the crypto and go up to Vegas or whatever they're going to do. And you know, how long do you think it takes the average person that inherits an IRA? How long do you think it takes before they've cashed the whole IRA in? Now keep in mind, under current law, they can spread it over 10 years. Law allows, when we were all kids growing up doing estate planning, you used to spread the IRA over the lifetime of your kids. We used to have a stretch over lifetime. Now we only can have a stretch on our IRA for 10 years. Anybody have a guess? What's the average year when those kids cash the thing in 100%? Forget the stretch. I'm paying all the income tax. It's all found money. Does anybody have a guess? How long? How long? 3? You say 3 years? 1? Yeah. The average is 18 months. So it's right in the middle. 18 months. That's what I love, all these financial advisors that talk about stretch IRAs and stretch it out in 10 years and protect it. They cash it in 18 months. That's why we set up IRA look-through trusts that we're going to talk about in a minute. This subtrust right here that I set up for my kid, I can make that the beneficiary of the IRA and not the kid. And the reason I've named that the beneficiary of the IRA and not the kid is they can't cash it in 18 months. I can force the 10-year distribution on them. Also, if I leave the IRA, let me ask this question. If I leave my kids, I die, I have $1 million IRA, I leave it straight to my daughter. My daughter's in a car accident the next day. Can creditors reach an IRA? Who wants to guess on that? What do you think in the back? Creditors, can they reach an IRA? Anybody want to guess on that? Okay, we got a yes, maybe some no. The truth is, if you're the one that earned the IRA and you created it, and it's your retirement, the law will protect you. IRAs are protected from creditors if we're the ones that earned it. But when our kids don't earn it and they inherit it, there is no protection. And I saw that in my change in my career when I was a young lawyer 20 years ago, 30 years ago. IRAs were even protected in the hands of our kids. And there was a case that went up to the Supreme Court and some creditor said, this IRA is not, that kid didn't earn it for retirement, it's just another inheritance asset. And the court says, yeah, you're right. There's no protection to a kid. So this subtrust is what you want to create for your kids. And let me tell you, don't tell me, oh, well, they'll just create their own trust. They can create their own trust for what they have on their own. But if they create their own trust using your assets that they got from you, there's no creditor protection in creating for yourself. To get creditor protection, you have to create for somebody else. You have to create that for them. They can create for themselves, but they have no protection. You can create for them, they have protection. Now I want, when I die, their share of the inheritance to go in that protected environment. Now I can control where it goes after my kid dies. I can control that, hey, you can't give that to a spouse. If you die, it's going to go to your children. It's going to stay in the bloodline. I can control that. Without that subtrust, as Hallie mentioned, I can't. I die, give it to a child, that child gives it to their spouse, and then the child dies, that spouse remarries, it's going a different direction. So it's pretty clear when you read my articles. I think it's a huge mistake to die and leave your inheritance to your kids. It's better to create these subtrusts. Now, let me give you a line to draw. If each share that a kid's going to inherit is going to be in that, let's say, $750,000 range or below, you could argue maybe that's too cute, maybe we don't need to do that kind of protection. But if their share of the inheritance is going to be $750,000 or above, I like the subtrust. And now I can build in here age restrictions. How old do they have to be before they get the income automatic? How old do they be before they can start tapping into principal? How old do they have to be before they become their own trustee? And I like that. I don't know if you picked up on Hallie, she used a comment of training wheels. Training wheels means our clients will say, look, if I die and you're under the age of 35, we're going to have an independent professional trustee up here. And later on, we're going to talk about who that independent professional trustee could be. But you're going to have somebody professional. Now, when you turn 35 and you've had 3 years of experience with a professional, then we'll let you be your own trustee. That's what a training wheel is. You don't just die and let your kids manage this wealth. You want to make sure they're at least a certain age. They'll work with a professional for a certain amount of time. One of the biggest fear I see that my clients have, especially as they accumulate more wealth, is ruining the kids, spoiling the kids, taking away their incentives. We'll talk a lot about that here in a minute, but let me stop. Well, let me go to one more. The next flow chart, Michael, let's go to this. And this is the one that doesn't have a name at the top, over on the left-hand side. And I want you to put AB+. AB+. It would take a very skilled person to see the difference between this flow chart and the prior one. In fact, there's only about 3 words that are different. But those 3 words are extremely powerful from a tax standpoint. And it has to do with this, bud. It has to do with, I die tomorrow, Nancy splits these assets A and B. When I die tomorrow, Nancy's still alive. Let's just say our total estate is $3 million. It's community property. I own half, Nancy owns half. I die tomorrow, Nancy's still alive. How much do we get to step up basis to Nancy? Does she get a step up in basis just on my half? I'm the guy that died. Does only $1.5 million step up? Or does she get to step up all $3 million? Even though she's still alive, even though she hasn't died. Who wants that one? I died, Nancy's alive, $3 million estate. How many say we can step up only to $1.5 million? Okay? How many say I can step up the whole $3 million to Nancy? I can step up the whole $3 million to Nancy if I have them titled in a trust as community property. That's what we call in our world a double step up. Now, I love this one when I go to these advisors doing estate planning. I say, explain to me what a double step up means. They say, well, it means when the husband dies, you step it up, and then when the wife dies, you step it up again. No, that's not what it means. It means husband dies, wife is still alive, and you step up both halves. That is a Christmas miracle. That's a gift from the IRS. It only happens in about 10 states that are community property states. If you're coming from back east, you don't have that double step up. We have it here in Arizona, and we want to make sure we have it. Now, the case I was talking about in California, they had a trust, but they had a house in California that wasn't in the trust, and that house was owned as joint tenancy with right of survivorship. It wasn't owned as community property. It wasn't inside the trust. There's a real legal question, Patrick. Patrick's our newest lawyer, just took the California bar yesterday. Give Patrick a hand. Do they talk about community property on the bar exam?
Not this one.
Not this one, okay. There's a real legal question whether you can step up a double basis on joint tenancy. And there's an example when I'm telling you it's not automatic. But this double step up is powerful. And that's another reason why you don't want to give assets to your kids while you're alive. Wait till somebody dies and they get the step up, then it goes to the kids. I get people coming to me all the time saying, hey, we got this cabin up in Pine Top, or we got a place over on the beach. I want to give it to the kids now. And you know, well, how long ago did you buy it? We bought it 20 years ago. We paid $400,000 for it. It's worth $2 million today. Well, if you give it to the kids now, guess what? They get it with the $400,000 base. So when they sell it for $2 million, they've got a huge capital gain. But if they inherited it through your trust when you die, they get that step up in base. There'd be a $2 million step up. They can sell it the very next day. That's what I'm calling a Christmas miracle. Now, all right, let's go to the next one. I died. We stepped up the whole $3 million. We put $1.5 million here in the red box, $1.5 million in the green box. Now Nancy dies 10 years later, and everything's doubled. Now there's $3 million in each trust. $3 million in red, $3 million in green. What do we get to step up now? I think we'll all agree we get to step up her red box. That's still a revocable trust to her. Section 1014 of the Internal Revenue Code says if you die and assets are in a red box, you get a step up in base. We'll all agree on that one. Here's the question. Will we get a second step up in base on the green trust when Nancy dies in the future? Now, we just got through saying she got a full step up on both sides when I died. Going in, she got a full step up. She dies 10 years later. Are we going to get a step up over here? How many say yes? How many say no? How many don't know? And I'm telling you right now, the way 90% of these trusts are drafted, she would not get the second step up on the green box. She would not. That power of appointment has to be drafted very different. See where here I said the word taxable power of appointment? And notice that I added to creditors of a spouse. Go back, Michael, to the other one. The other one said non-taxable power, and you see no mention of creditors. There's the 5 words that are different. Those 5 words mean no second step up in basis. Great job, financial planner, for helping me on my estate plan. They don't understand this. That second step up is critical, and you have to have the right magical words. All right, enough on these trusts. Let me stop right there and take a few questions. First of all, you know, hopefully most of you are familiar with this A-B split concept. To summarize it, I like the forced mandatory split. I don't like the optional one. And I want the AB plus, where I'm going to get a second step up in basis on the green box. All right, questions on that, on the AB split? We all good? Come on, Michael. Oh, you got a question here?
So when it says survivor's property plus 1/2 of community property,
Yeah.
that's not necessarily then 50-50.
His question is, it says up here, survivor's property plus 1/2 of community. It's not necessarily 50-50. It's a 50-50 if everything they own is community.
Yeah.
But sometimes, you know, wife inherits something. She doesn't trust you if she dies first. She keeps it her sole and separate property. So if she has sole and separate property and she dies first, what goes into her green protected box is her sole and separate, those oil interests she earned from her parents, plus 1/2 of the community. So they get both. Good question. Other question? Yes, sir.
So you talked about naming the subtrust as a beneficiary in the IRA. So one attorney that I spoke to said, you know, if you take the distribution, so let's say it's over 10 years because it's changed the stretch.
Yeah.
Let's say for sake of conversation, there's $100 million in there, so you'll take them 100,000 each year unless there's other
Yeah.
reasons why you want to change it. So you take that distribution, and because it's in the name of the trust, you can actually funnel it, or you have to funnel it through the kid's subtrust, the irrevocable one. And if you don't pay that, and then you funnel it through there, and then you give them that distribution, and if you don't, you leave the money in the trust account, it gets taxed at the trust tax rate, as opposed to distributing it out. And you could, but you could leave it in there, and he talked about something as income versus cash. So if you pay tax on that distribution, you then can leave it in that irrevocable trust for the kids, so it's protected from creditors and the spouse and so forth. So my question is, you got to take the 10% or whatever, or whatever. Can you leave it in the kid's subtrust to keep it protected, but just pay the cash on that, you know, as if it's...
Pay the tax, yeah. Couple really good questions here. So the debate is, and this is the biggest debate, and by the way, if you'll see my business card in there, send me an email on that question. I actually wrote an article on who should be the beneficiary of your IRA. And I debate, should it be the spouse for the rollover? Should it be straight up to the kids for the 10-year stretch? Should it be a trust, so on and so forth? But his question was, I've got this $1 million IRA, I die. I'm recommending that you leave it to this sub-trust instead of your kids. He's got the rule right that if I die and I leave an IRA to a trust instead of a person, the general rule is, Patrick, that a trust only gets a 5-year stretch and a person gets a 10-year stretch. That's the general rule. And so some advisor will say, never give it to a trust because you're stuck with a 5-year rule instead of a 10. Now, later on we'll talk about what we call a look-through trust, where with a look-through trust, I can send it to the trust for creditor protection, and I still get the benefit of a 10-year stretch. Look-through means we're looking through the trust and see the beneficiary out there, so I can still get the 10-year stretch. Now, his next question was, well, all right, well, what about the income tax on that? So I'll put my CPA hat on that. So when that IRA makes the distribution, by the way, you talked about a 1/10. It doesn't have to be, it has to be within 10 years, so you could go 0 distributions and then all in the 10th. But let's just say it's 10% each year, 100,000 is going into that trust. The rule is very simple. If that 100,000 stays in the trust, then it's taxed at the trust rate, which will be higher than the kids. A tax rate for a trust is the highest bracket known to mankind, where if it goes out to the kid, it's at their individual rate. On the other hand, so that comes in, I'm not wanting to leave that money in the trust. That's something you don't want to accumulate because that tax is too high. When it comes in, I'm going to kick that 10% out to the kids. I'm not doing that to keep that 10% locked up in that trust. I'm kicking it out to the kids. They will pay it at their rate. We won't have to pay that high tax rate. Are you hearing me on that?
Yeah, I was just thinking in terms of being able to protect it. So this was somebody else I talked to, said you pay the income tax on that 10% or whatever you put in there. But if you leave it in there, you're protected from creditors.
Well, there you go, but that...
You can pay the tax on it.
Yeah, sure. I can leave it there and pay the tax to get the protection, but to me a 40% income tax rate is a high price for protection. And that's just a choice you have to make. I would rather pay it out to the kid at a lower rate. Okay. Because usually you want that trust, usually they're taking someone out of that trust anyway, so I'd have it go out.
He was saying if you paid the tax, if you go ahead and voluntarily pay, you can pay it at the kid's tax rate, you can leave it in there. But everything I read said if you leave it in there, you don't.
You can't voluntarily pay. Let's take a look at subchapter J of the Internal Revenue Code that talks about. There's no thing about voluntary. If I leave it there, I can pay it at my rate. No, it's either very simple rule. If it stays in the trust, it's at the tax rate. If it comes out to the kid, they have to pay the tax at their rate. All right. Other questions on that? AB trust, yes, sir.
On the descendants trust, that's an irrevocable trust. Do you still get a step-up basis on that?
Okay, so let's go through that. I love that question. So we're back to step up in basis, and I want you to sleep and dream and have really pleasant dreams about basis, because that's where tax law is right now. On the estate tax side, that $14 million estate tax exemption Most people think Trump's going to roll that over. So between a husband and wife, estate tax is only an issue for over 28. So estate tax is not the issue. Capital gains and step up in basis is where the actions is. So you want to make sure you get a step up. So here, we know we're going to get the step up here, right? Because I went through that. Now your question is when the kids die, will they get a step up in basis? Same rule. It depends on how I draft that power of appointment. Now notice here I use the word taxable power. That will give me a step up when the kids die again. But that power of appointment has to be drafted the right way. Without it being drafted in the right way, being drafted poorly, they will not get that step up. Good question. I want to get into now, I'm on striking a balance between beneficiaries. This is the 68-year-old gray hair coming out in me. What if you have a spouse that's a recent new spouse and you have kids of a prior marriage? How do you strike that balance between what you want your wife to inherit versus what do you want the kids to inherit? And we know that with a newer spouse, the more we give that newer spouse when we die, we're not able to control where it goes after that. And so in the outline I recommended that you do consider maybe a life insurance policy if you're young enough and still healthy enough. Let's say you have, I'll make up a hypothetical, let's say you have a $3 million estate, you have a spouse that's you've been married to for 5 years and you've got these kids from a prior marriage and you want to die and love them both and you want to take care of your spouse that's taking care of you. I just argue in the outline, why not have it go home and say, honey, I've done a great thing. I'm going to leave my entire estate to you. And then just buy a life insurance policy for the kids. Create 2 estates. Buy a $3 million policy. Maybe the premiums, I don't know, $5,000, $10,000 a year, but now you're creating 2 estates. I'm just giving you that as an option. Another option in striking that balance is whatever you leave your spouse, put it in a restricted marital trust. We call those Q-tip trusts, and I mentioned it in an outline, where I can put it into like a green box where I can say, spouse, I love you to pieces, but I'm only going to let you have the income from the trust, not the principal. And I'm not going to give you a power of appointment. And so you can have restricted marital trust. But I'm just saying, striking this balance, you need to think about that you love your spouse and you love your kids, but don't be so naive to think, well, my spouse has promised me, on a stack of Bibles that, she'll never disinherit my kids. You can't have that promise. Put it in a restrictive trust. I also talk about in here striking balance between kids and grandkids, and I already talked about that. And clients are all over the board on this. I find, generally speaking, clients kind of agree with me. They like their grandkids better than their kids. And so in my estate, I already told you, half of my net worth is going to my grandkids. I feel like I've spent a lifetime educating my kids, and I'm very proud of my kids. Out of 5, we ended up with 4 lawyers and 1 dentist. They'll be fine, right? I've paid enough tuition. Now it's time to think about the grandkids. Strike that balance, and have these sub-trusts created for the grandkids. And there again, you can talk about different ways to set up the grandkids. Do you have one trough that all the horses drink from the same trough? Or do you have separate troughs for each of the grandkids? And there's different ways to do that. Do you set it up where they can only use the fund? In my situation, I set it up where they can only use the funds to further their education and make their lives better that way. And then I put that whatever they haven't used by age 30 comes back to my kids. So you can create all kinds of incentives to strike that balance. The last one I talk about in there is striking a balance between kids and grandkids and also charities. And there again, I find clients are liking the idea of giving back, right? And some clients are big believers in tithing, and they'll have 10% go to a charity. Other clients will be more generous, and there again say my kids are going to be fine. I want to have stuff going to the charities. I think striking that balance. And then when you start thinking about charities, we want to be smart how we do it. We want to make sure that with charities that we have it where we can get some income tax deductions while we're alive, even though charities don't receive anything until we die. And that tool is called the charitable remainder trust, but the IRS is very generous on charitable remainder trust, where we can set them up while we're alive. We get all the benefits and the use and enjoyment from the trust while we're alive. Nothing goes to charity until we die. But just by setting it up, the IRS will give you charitable deductions while you're alive. So I think those are fabulous tools. But I think they're again things that I know that I've gotten better at because I've wrestled with them myself on these issues about striking that balance. But anybody have any questions about that section about, I don't want you to look at your beneficiaries and just think, oh, well, you know, I'm going to do like the form says, I die, it goes to my spouse, she dies, it goes to the kids, and everybody goes home. That's what these forms say. No, let's give that a little bit more thought, okay? You know, maybe we split it between spouse and kids, and maybe what we give the spouse is more restricted. Maybe what we give the kids is restricted until they reach certain ages. Maybe we give some of that to charities, right? Go back to my article again, Planning with Purpose, and I like to use an estate plan almost like a letter to your loved ones after you die, where in a minute I'll talk about what we call thank you notes, where I might have, you know, some things go to my favorite nieces and nephews that went hunting with me. And maybe I want to give them some cash gifts, and maybe I want to thank them for being a part of my life. And, you know, not just die and give it to the kids, right? Let's give a little bit more thought into those beneficiaries. And if anybody's interested, I couldn't put all the articles in there, but I also wrote an article, I call it 3 Tiers of Beneficiaries. If you're interested in that, send me an email. But I rank beneficiaries Tier 1, Tier 2, and Tier 3. Like, you know, in my mind, a spouse is a Tier 1, kids are Tier 2, and, you know, and then maybe you get down to charities and distant relatives as a Tier 3. But you'd be surprised the number of clients that come in that really don't know how they want to split it, and they want to hear ideas, and they want to hear what other people do. And I think reading these articles, seeing what the options are very beneficial. Any questions on that segment there about these different tiers of beneficiaries and balancing that? Yeah.
With the charitable remainder trust, where you said you're getting the deductions while you're still alive, how does that work?
Yeah, that's a good question about the charitable remainder trust. It's kind of beyond the scope here, but send me an email. I wrote an article on charitable remainder trust. And I actually, in my mind, I compare a charitable remainder trust as being better than an IRA. Everybody's out there worked up about IRAs. I'm telling you a charitable remainder trust is better because it has 3 tax benefits. But basically you set this trust up, put $1 million in it. You can manage the trust. You take out $80,000 a year for the rest of your life. And when you die, the remainder goes to charity at your death. And IRS will give you a deduction up front in the year you set that up. I mean, so that's a pretty useful tool, even though charity doesn't get the dime until the back end. But there again, beyond the scope here, ask for the article, read that, and if you have any questions, we can go through that.
Okay.
All right. Any other questions on the balancing act between beneficiaries? The next section I get into is using an estate plan to create legacy. I've kind of talked about most of this already. Use of the thank you notes. What I call thank you note, and I'm on page 7 of 13. What I call a thank you note is in your document, it'll say down here, before it passes out to the kids down here in this green box, it'll say, make the cash gifts to the people that I've listed on Schedule B attached. I want $10,000 to go to Jared Windsor. I want $20,000 to go to Nora Yates. And with these thank you notes, I can change that Schedule B without coming back to see the lawyer and getting it notarized and witnessed and all that hoorah. They're very easily changed. So that's what we call a thank you note. where it's very easy to say 10,000 to my favorite nephew, thank you for hunting with me. My favorite, granddaughter, thank you for calling me every day. And then, then she quits calling me, then I can take her off the thank you notes, right? So it's very simple. And then I guarantee if you tell your grandkids that you have thank you notes, you'll get those calls every day. It'll be amazing how often they call. I already talked about providing incentives for the kids. We don't want trust fund babies. Once in a while we'll put in a clause, earn $1 and we'll give you $1. And you can do those kinds of things. When I was a young lawyer, I had too many restrictions in there. You do this, you get this, you do this, you get this. I'm not that controlling from the grave anymore. And I don't really have this earn $1, get $1 type concept, but some clients have it. Some clients will want drug testing in there. We see that once in a while, but especially if it's with grandkids and stuff. But I'm just saying you can put these bumper guards in there for the kids. We talked about the subtrust already. I talked a little bit about charitable planning. Strike that balance between providing opportunities without being too controlling. Be careful of the hand controlling from the grave. And to me, where I strike that balance for my kids is I have it where, and this could apply to a grandkid too, if they're under age, say 25, they have to go to a trustee, whatever their needs are, support, health, education. Once they turn 25, I'll give them all of the income, and that goes back to your income tax question. Holding income in a trust is very expensive. They get in those top rates after like $13,000 of income. So I'm a big believer kicking that income out, tax it at the smaller rate. And so I draw that line at 25, I'm kicking the income out. At age 30, I give them the right to withdraw 5% of the principal for any reason. They want to go tour Europe for the summer and their trustee says, no, that's not support and maintenance. They can say, give me 5% of the principal, no questions asked. And then at 35, I let them be their own trustee as long as they've had at least 3 years of training wheels. So there again, I'm trying to strike that balance between some controls, but not too controlling. A question on that or anything? We're okay? Everybody on that? Let's go into the fiduciary section. I list that as mistake number 6 in my mind, not enough discussion on who should be your fiduciaries. There again in my article, Planning with Purpose, I've talked about, I've compared my life to Tim McGraw, country western fan. I love that song. In my next 30 years, I'm going to eat a few more salads and go to bed a little earlier and do this kind of stuff. And I kind of equate that to estate planning. I'm in my next 30 years, right? My first 30 years, I was a tax attorney. I was a tax nerd. I'm CPA, master's in tax, and everything was tax, 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 tax. And we let the tax tail wag the dog. Well, my next 30 years, I've slowed it down a little bit and said, you know what? I don't think there's been enough discussion on who's going to be the trustee when you die. Should your surviving spouse be the sole trustee, or should there be a co-trustee? What happens when you both die? Who settles the estate? Do you pick one kid over the other? Do you pick all of them? I choose to pick none of them. I want somebody independent. And if I choose somebody independent, do I want to go with a big corporate trustee like a Northern Trust? Do I want to go with a licensed private fiduciary that's kind of like a paralegal trustee? And in your materials there, I gave you an article I wrote called, Successor Trustees and what my thoughts are on it. But I believe who your trustee should be, first of all, they need to be somebody that is easy to get along with the entire family. They should be somebody that has good business sense. They should have a basic understanding of basic tax law. Like I say, I'm a big believer in not using any of the kids. I don't want to use my Uncle Billy Bob Thornton or whoever Billy Bob is. I want somebody independent. I really like these private fiduciaries that are out there. If you've never Googled that, go online and say private fiduciaries in Phoenix. You'll see probably 20 or 30 of them come up. They're licensed and regulated by the Supreme Court, just like we are, that are members of the bar. They answer to the same agency. They're bonded and insured. They don't charge any fees until you die and they come in and serve. And then they charge hourly rates depending on what services they're asked to do. And you can go on there and they publish their fees. They're private fiduciaries. Their highest hourly rate is generally in that $175 an hour to $200 an hour, which is lower than our lowest paralegal. I mean, it's lower than no, it's not lower. It's not as, our lowest paralegal rate of our law firm is around $225 to $250, is much higher than their highest paralegal rate to be a trustee. So I think they're the best bang for your buck. I'll put a plug in. I started a private fiduciary company 25 years ago called Scottsdale Fiduciary. It's now named in hundreds of documents, and it's run by my daughter, Kendall Yates. That's a licensed fiduciary, and Kendall was a paralegal in our law firm for 15 years, and she has a finance degree, and she's very bright, very good. But I'm sure there's other good private fiduciaries out there. Whoever we put in, we will give the kids the power to remove and replace. We don't ever want to be in a document where we're not wanted. If they want to remove and replace us, that power they have. We just make sure that they have to replace us with another professional fiduciary. They can't replace us with their new spouse or the neighbor across the street. And in my opinion, you need fiduciaries that handle money. That would be like your successor trustee. That would be like maybe your power of attorney. That might be like your executor under your will. I'm a believer in these fiduciaries. You also have fiduciaries that make healthcare decisions, your healthcare power of attorney, your living will, you pull the plug. I'm a believer there. You do use family members, you use spouse, you use kids on the medical stuff, right? Most professional fiduciaries don't want to be in the business of deciding whether they pull the plug on you or not, but I think they're very good at that. But if you feel like you're a little bit uneducated on what the options are on fiduciaries, look at that article. I spent some time writing it from experience, and I think there's some good options. But don't, when I was a kid growing up practicing law, they gave it to the oldest son, right? Whatever reason, they gave it to the oldest son, and they had that pecking order with no thought of qualifications. And I just remember when here's an example of that. Would be a situation my dad's estate plan was one of the first ones I did coming out of law school, and I let him name me as a trustee, which was a huge mistake. I would never put that on anybody. I started having older brother come and, my mom was still alive, so I was protecting the wealth for her. But a brother would come along saying, hey, I need some money to buy a new Suburban for the kids, and I can't get a loan at the bank, but I'll pay mom a higher interest rate, so it's good for mom. Well, you know how that's going to turn out. He's not going to ever pay mom back, and I tell him, no, we're not going to do that. Give that a lot of consideration. I think there's some good stuff there to think about. And then the last thing that I want to hit, and then we'll turn it over to Michael to hit a couple of these. I'm talking about these trusts that we saw, these irrevocable trusts. They're going to last for the lifetime of our kids. And you can have them last for the lifetime of the grandkids. And now under Arizona law, you can have a trust last for 500 years. In states like Nevada and South Dakota, you can have a trust last forever. And, it's one thing I've really enjoyed about my career is I've had a few of these trusts now where we're working with Generation 3. Grandpa set it up and's gone, and parents are gone, and now we're working with the grandkids. And seeing some of these trusts that were set up in the 50s by, wealthy families, these trusts, and I'm telling you, I think that's the way to go, because these trusts provide that creditor protection. And these trusts that we create for our kids, we call them generation skipping trusts, which means once they get into that green box for the kid, they can pass to grandkids with no estate tax. I don't care what they're worth. And when the grandkids die, no estate taxes. Generation skipping means we're skipping the IRS. It doesn't mean we're skipping the kids. And these wealthy families, you want these generation skipping trusts where you're passing wealth from one generation to the next with no estate tax. In this flexibility that we talk about, I already talked about powers of appointment. I listed that at the top of page 9. Even though that trust is irrevocable, I do want my kids to have some power to say who it goes to when they die. And I can give them that power of appointment. And I can draw that very narrow to say you can only give it to descendants. I can start to loosen it up and say spouses of descendants. I can loosen it up and say charities. Or I can loosen it all up and say you can give it to anybody in the world. I can draft that power of appointment to be very narrow or very broad. But if this trust is lasting a long time, I can't foresee all the things that are going to happen with my grandkids, but my kids will see that, and I want them to have that kind of flexibility on these powers of appointment. We talk about disclaimers. We use disclaimers inside of trust. That could be something like, I leave my assets to my spouse, but if she disclaims those assets, then I want it to go to these 2 kids, but not this kid. A disclaimer is something where you can have a pecking order to say, I'll give my next person in line the chance to say, I don't want it. And if they say, I don't want it, then I can dictate where it goes instead of they dictating. I don't want to give it to somebody and they say, I don't want it, and they're going to give it to a new spouse. But I want them to say, I don't want it, and they can give it to, it comes to my kids. So that's what a disclaimer is. It has to be drafted in the document. You can't give them that choice after the fact. Trust protectors. That's kind of a new baby in trust law. It's been around for probably about 20 years. In the practice of law, that's still infancy stages. But trust protectors, I can give somebody the power to do things that I can't have my wife or kids have that power. For example, we talked about these trusts being irrevocable. My spouse and my kids can never amend that trust. Now, they can have that power of appointment to dictate where it goes when they die, but they can't amend the trust. But I can create a trust protector that can have the power to amend the document. If there's changes in tax law, if there's changes on step-up and basis, if there's changes on the estate tax, I want a trust protector in there. I can have a trust protector take beneficiaries out. I can have trust protectors add beneficiaries in. Trust protectors can have any power that I can't have. And so guess what? Trust protector in my trust is my law partner, Trevor Whiting. What a better trust protector. I die and Nancy's back. How was the shopping? Well, not enough time. I don't see any bags, so is there going to be a shocker out there? Yeah, can't get in the car. We'll have to take an Uber home. But trust protectors are something we really like in these documents, because even on that AB trust, I die. We split between the red box and the green box. That's irrevocable to Nancy. But we can have a trust protector, Mr. Trevor Whiting, where he can make an amendment to it if tax laws are different. What if the estate tax is finally repealed? Maybe we don't want this. What if stepped up basis is different? I've been practicing for 40 years, and in that 40 years, I've seen a lot of changes. When I came out of law school in 1984, the exemption was only $250,000. Actually, strike that. It was $250,000 in 1981 when I was in the accounting program at ASU. Ronnie Reagan is the one that raised it to $600,000. That was a big deal. And then those of us who are long enough remember, George W. Bush, they come along and they put the exemption at $1 million. Then they tied it to inflation. And we saw it get it up to $3.5 million, and we're all dancing in the street. And then Obama comes along and he raises it to $5 million, and we're dancing in the street. Trump comes along and raises it to $14 million. And so there's still some people wondering whether it'll stay at that 14. It's scheduled to come back to 7. We don't know. My personal feeling, I do think it will be extended, but there's a possibility. I think the capital gain issues are more important to Trump than the estate tax issues. Because if you talk about billionaire and millionaire clients, it really doesn't matter, and I have some of them. It doesn't matter to them whether the exemption is 14 or 7 million. If they're worth $250, $300 million, the exemption doesn't matter. But what matters is capital gains and the capital gain rate. So there are some advisors I'm seeing on the internet saying, don't be surprised if that 14 million does come back to 7 if Trump needs it as a wild card to play to get what he wants on corporate tax rates or capital gains. We just don't know. But keep your eyes on that. But this is what I'm talking about, building flexibility into the document. Michael, am I on the home stretch here? Mr. Michael Rich. How many think he looks like a teddy bear? Huh? It's like, he tells me that everybody calls him a teddy bear, and he says some of the single widow ladies like to give him a hug. But I tell him, Michael, whatever it takes, just go with it. Michael, go ahead. Michael's been with us almost, 2 years? He came to us from Oregon, past the Oregon bar and the Arizona bar. And I tell you, you met Hallie. Hallie is a huge rising star. Hallie's been with us about 10 years. And I found Hallie because she lives across the street from Kendall, my daughter that runs Scottsdale Fiduciary. And told Kendall, I need some new lawyers. And she told me about Hallie. We hired her right out of law school. Huge rising star. You'll see with Michael Rich, also a rising star.
Just for the record, Matt's the only one that calls me a teddy bear. I didn't tell him that anyone said that. So the last couple topics I'm going to talk about are kind of some of the simple mistakes that we see on a more daily basis. And this one here, I always tell my clients when we're sitting in the conference room signing the trust and they're breathing that sigh of relief saying, I've been waiting to get this done for 5 years, 10 years, some of them their whole lives, and they feel like they're done. I always tell them we're only halfway there. Setting up the trust is only the first half of the battle. Once we have the trust set up, you have to fund it. When I say fund the trust, do people know what I'm talking about? Yep. A lot of people think that as soon as they set up the trust, automatically all their assets are transferred into the trust. They think it's like a will, that when they sign that will and they say, when I die, all my assets get distributed in this manner, they think the trust does the same thing. But all these amazing things that Matt's been talking about double step up in basis and creditor protection and stretch IRAs that happen inside of the trust, that only happens if the assets you own are transferred to be owned by your trust. And so the first thing we talk about is, we have all these assets, your homes, your bank accounts, your investment accounts, they're all titled in your name, or you and your wife's name, or husband's name. They're titled together. And one of the documents we prepare for you when we set up this estate plan is called a certification of trust. And really it's just a 2 or 3 page summary of the important trust terms that you can give to your financial advisor, that you can give to your banks, that will take those assets out of your individual name and then title them into your trust name. I can't tell you how many times I sit in front of clients that come in with estate plans drafted by other law firms or other attorneys, and one of the first questions I ask them is, how are you doing on funding? And they just give me blank stares. They have no idea what I'm talking about. They just assume that everything was inside the trust. When we transfer it inside of the trust, then that split that Matt talks about, those creditor protected trusts for the kids Matt talked about, then those come into play. If we don't put things inside of our trust, we have something that goes with the trust called a pour-over will. And what that pour-over will is designed to be, it's designed to be a safety net. That in the event you forget to put something in the trust, that will says, at my death, put it into the trust. But as we talked about at the beginning, the downfall with wills is that they trigger probate. And so if we have relying on this pour-over will to put all the assets into the trust when we die, well, we're still just going to end up in probate. And if we get back to the very basics of the trust, the very beginning of the seminar, one of the most basic benefits of the trust is that it avoids probate. So if we rely on this pour-over will to put everything in the trust when we die, well, we may still get some of the benefits of the trust, but we're still putting our kids and beneficiaries through that probate process that we don't want to do. The other thing we talk about is that when we've put assets into the trust, there's always going to be a document at the end of your trust called a Schedule A or something similar to that. And that's where you can write down on that document what assets you've titled into the name of the trust. In that document, it's not legally binding. Just because you wrote something down on that Schedule A does not mean it's in the trust, right? You still have to go to the bank, you still have to go to the title company and actually physically retitle the asset from your name to the trust name. But when you keep this Schedule A current, when you're gone, when that fiduciary company, when your kids or whoever that trustee is can come and look at that Schedule A and say, now I know where their assets are titled, it makes the administration much, much easier because we're not sitting there trying to dig through mail and emails for months on end saying, oh, I think they have an account here and I think they have an account there. We know where your assets are. So you always want to keep that Schedule A current. And then the last thing that we want to do is transferring assets into a community trust can change them from being a sole and separate asset to a community asset if we want it to. And we like things to be community, right, because we get what's called that double step up that Matt talked about. When things are your sole and separate property, we don't necessarily always get that double step up. But if we can put them into a community trust, we can take full advantage of getting the step up, avoiding probate, and making it easy on your beneficiaries after you're gone. Now, after we've funded the trust, we have to remember that not everything goes inside of a trust. There are some assets, the best example that we talk about are IRAs or 401ks. We can't change the owner of those assets to be a trust. It's inherently an individual retirement account. It's going to be in your name. So that's going to go via beneficiary designation. So even though the trust may hold the bulk of your estate, there's still going to be some assets like an IRA, like an annuity, like life insurance that's going to stay in your individual name. And we want to make sure that the beneficiaries are kept up to date on that, right? The trust does not dictate where those IRAs or where those life insurance policies go. The beneficiary designation will. If we talk about how things are going to pass when you die, the order of priority is number one, beneficiary designations, right? If you have an asset with a beneficiary designation, it doesn't matter what your will says or your trust says, that asset's going to go via that beneficiary designation. Okay, so when we keep some assets outside of the trust for a variety of reasons, maybe we can't put it in there, maybe we're holding a separate life insurance policy to create a second estate for the kids. If we're not keeping those beneficiary designations up to date, we may have done all this work to set up your trust the way you want it to be, but then we have these other assets that are going to someone completely different that you had set up when you opened up the IRA or the annuity 25 years ago. So we want to make sure those are coordinated, and we spend a lot of time making sure that your beneficiary designations and your trust are talking to each other so that they pass the way you want them to. The titling of real estate, we've talked a lot about that already, about joint tenancy and rights of survivorship and community property. A lot of that goes back to the capital gains aspect of the double step up in basis and getting the asset to a point where you can pass it to a surviving spouse or to your kids and they have the best capital gains tax scenario possible. Real estate, we really like being in the trust, right? That's one of the biggest things that's hard to transfer without probate outside of a trust. Now, again, going back to your question, a lot of times we put assets into the trust like real estate, we're just going to assume that it's community property, okay? And that's just how we want our real estate to be titled. The next slide, this last slide, is failing to consider the other ancillary documents that go with your trust. The trust is the big thunder in the estate plan. That's 95% of the time that we spend with you is designing this trust and these trusts for these kids to make sure that it really fits your family needs. But the other thing you have to consider is that there's also ancillary documents that go with it. Who's going to be your financial durable power of attorney? Who's going to make the healthcare decisions for you? How are you going to fill out that living will so that you can dictate to your agents when you're on your deathbed, what kind of treatment do you want to be given? What kind of treatment do you want to be withheld? making sure we have our beneficiary designations up to date. So when we go through the trust, even though we spend a lot of time on that, it's also really important to spend time in making sure that the agents you list on your trust and on your wills and your beneficiary designations also match up and are in line with who your powers of attorney are as well. You know, powers of attorney are important to have because those are the baseline documents that we're going to have while we're alive. If we're incapacitated, the banks are going to want to see that power of attorney. The doctors are going to want to see that power of attorney. So it's really important to keep those up to date along with your estate plan. Powers of attorney typically don't expire, but they can frequently go stale. If you have a power of attorney that's 40 or 20 years old, 30 years old, the bank may look at you a little cross-eyed and say there's probably a more up-to-date power of attorney. So it's important to keep those ancillary documents up to date along with your estate plan.
Thanks, Michael. I just want to hammer a couple things on what he talked about funding, and you know, it always surprises me when somebody dies and we have a beautiful trust that was in place, and we've got a pretty binder that was in place, and we've got the deeds transferred over and this and that, and we come in and there's always something that was overlooked, right? I bought a timeshare in Hawaii and forgot to put it in the trust, or bought a new car and, you know, should that have been the trust, or, you know, how did I title that, or gosh, I inherited that mineral interest last year and I own it with my siblings and it's a complicated asset and I never put that in the trust. And I don't know if there's any statistics that can be kept on this, but I just have a feeling, and this is just my 40-year gut talking to me, that people with trust, I guess that at least 50% of them still end up in probate. And I think it's partly because they just weren't funded properly to begin with. And then I think that also causes where life gets in the way and they forget about it and they buy stuff and they're going to get, I get people say, oh, I'm going to sell that in 2 years, let's don't mess with it, right? And we've wrestled with funding for years as a law firm because it's something that we talk to the clients about, and you know, they get fee sensitive and say, we already paid you a bundle of money, you know, we're not wanting to pay for this and that and this and that. And so we're like, well, you know, go take care of it, and then they just don't, right? We're trying to get better as a law firm, and we're creating what we call a funding coordinator, where when we execute a new trust, we'll list everything that needs to be in the trust, and we'll just have you initial what you want to transfer yourself. And so we at least have a record that we talk to you about, because I hate it when the kids point at me and say, well, why didn't this happen? It's like, well, we probably talked about it and they didn't want to pay the fee, you know, a $400 fee to do a new deed and record it. And I think that with our funding coordinator, we're also going to teach them that, you know, 3 months after they sign the trust, call the client back up and say, now did you follow through with this, this and that, and then remind them. But that's a critical part, you know, is funding these trusts. The IRA that was talked about quite a bit, it is a complicated subject about who should be the beneficiary of the IRA. I think if you want to talk generalities, I think most people leave the IRA out of the trust altogether. Name the spouse as primary, the kids as secondary. You start getting into the reasons I talked about, maybe getting some creditor protection and some estate tax. Then we want to use one of these subtrusts and make sure we have those look-through provisions. But then we do want to consider the income tax, and, you know, are we going to leave it in the trust to be taxed at a higher rate? And that's one thing just from practical experience. Like I say, in my own mind, if I leave it in the trust, it's going to be taxed 40% for everything above $13,000, and that's just federal. Then tag on another 5% state. It's 45%. To me, that's too high a price to pay. You know what? I'll kick it out to the kid. I'll lose the creditor protection on it, but I'm not going to lose 45%. My kid's bracket's probably going to be 12%, right? So this is where you have to kind of weigh those practical decisions. I'm wrapping up the seminar here. There's two things I want to leave on. First of all, we left a survey right there in the very back, and you know, I hope you really appreciate the time and effort we put in this. You see all these articles I've written, the PowerPoint, you go online and see our videos. I do think we have more teaching materials than any law firm does in the state. And you can see all these materials. I really appreciate if you tell us about the seminar, how you heard about it. You know, what did you think of the content? If you didn't like my comment about the jackass lawyer, put that down there. If you thought the Ozempic was uncalled for, you know, put that down there. Nancy's here now. She can tell me in one seminar I talked about Depends, diapers, and she thought that was out of line. And so anything that I say, she's still shaking her head. You know, if you found anything I said offensive, forgive me. That's just, I'm an open book. Talk to us about what you liked about what I had to say, what you had Michael had to say. I don't have Hallie down there, but make sure you mention Hallie. And then I promise you we're not going to chase you. If you want to have an appointment with us, you know, check the box. Leave all these with Nancy on the way out. If you check the box, we'll get back with you. If you don't check the box, you won't hear from us. The other thing is Michael put up there on legal fees. And we have our schedule of legal fees right in the back. We don't want to hide anything. Let me see what that looks like, Michael. Find that. These are our published legal fee statement here. And I like to just show that to people because some people, when we ask for the financial information, they're hesitant that it's going to drive the price up. You know, the price pretty much is what it is. The price does go up when you start getting into those estates that are, you know, above that 14, 15 million. When the estate tax becomes more of an issue, then this document is, what we've talked about today, I'm telling you, is a Cadillac of all trust that will protect you up to 28 million if you're married. That'll give you a double step up in basis when both kids die. That'll balance those things we talked about. And we talk about in here, you know, if you go online and you look at the internet, I look at Instagram a lot. There's a lot of things on there that talk about the $4,500 trust. You see the financial guys talking about, you know, they can do it online for you for $1,500 or $2,000 or whatever. I just want to come back to what I start with. You get what you pay for, and what you're paying for with us is our time and our experience. And hopefully in this seminar, you've seen the 40 years of experience come out in all these articles and all these topics, right? Every question that was asked today, you know, I've dealt with hundreds of times. And I hate to say I've seen everything, but I've seen quite a bit, right? And I've seen it over and over again, and I've seen these fact patterns. And, you know, with us, it's not just you come in kind of a one and done in the situation. We're big believers in sessions. And we basically say, if you want to give us a try and not even commit, our normal rule is when somebody, you know, calls in off the street, we charge them $500 flat fee. Basically what you got in this today would be stuff that we would try to cover in a session with the client. Now with the client coming in, it's one-on-one. We don't have to hit 30 topics. We can narrow it down to their situation. But generally we charge a $500 flat fee to have a session to decide what type of a trust you want to do. And then we design it with these flow charts, come in for another session, we review the flow charts, and we change them. But I think there's an article back there, my newest article I just wrote was, I compare designing a trust like building a home. And I talk about there's a difference between a tract home and a custom home, and a difference in square footage and size of the estate. There's a difference in the bedrooms being the Subtrust for the kids. And, you know, I tell people, you know, if you want a good deal on a trust, send me an email, and for $100, I'll email you a pretty dang good form. But you won't understand all these provisions that I talked about, and which ones you want and which ones you don't, and that designing. So you're really paying for our time. And then if you want to proceed, we roll the $500 into the cost of the whole package. But I put in there on this because of I've pretty much given everybody here the type of session that we would give you. We're waiving the $500 if you want to come in and see us. There's no charge. If you have an existing trust, we'll have you email it to us before our meeting, and I'll have Patrick back here is getting to be our guru of flow charts, and he'll flow chart what your trust looks like today, and then we'll flow chart what we would do different. And then we could talk about whether we want to, in most cases where you have a trust already, in most cases what we want to do with that trust is we want to restate it where it keeps its same name, its same date. We don't have to retitle anything, but we can give you a brand new document, and that's called a restated trust. So I think with the Matt, Nancy, Dana, we have, you know, restated trust number 4 or 5, right? I mean, we've had our trust for 40 years, and we keep restating it, you know, every few years. Still wrestling with Nancy on some of our provisions in the sense that, you know, we are an all-American family in the sense that we've had a couple of kids that have already divorced. We have a son that has stepkids now. We wrestle, do those stepkids have the same priority as our grandkids? We have one son, you know, over the breakup of Dana Law Firm that hasn't talked to us since the breakup, you know, 7-10 years ago. So, you know, we wrestle with what do we do with his share? Do we give it to his kids? You know, these are things you just wrestle. These are hard decisions, right? And there's no right or wrong. But I can tell you what other people have done, and I can tell you what my opinion is. And then, you know, my job isn't to make decisions for you, but my job is to make sure you understand what the choices are so you make the decisions.